Ladies and gentlemen, welcome back to the Indie Zone podcast. This is Kathy. I wanted to call to your attention something that popped up rather late on the docket for January 31st, 2025, that relates to Mr. Kohberger's request for a Franks versus Delaware hearing. As you know, if you've been following the Indie Zone podcast, then I hope that you have, as the episodes do build on each other, back in November 2024. Mr. Kohberger filed an amended memorandum in support of his motion with various exhibits for a Franks versus Delaware hearing, which attacks the veracity of a warrant affidavit, an affidavit in support of a warrant signed under oath by law enforcement. If you have not already had an opportunity to listen to our prior episodes governing what Frank's hearings are, the very high burden of proof that a defendant must show to even qualify for a hearing, much less get the relief of having a warrant affidavit struck, please do. We've published prior content regarding what Frank's hearings are all about and the burden of proof, amongst other matters. Well, today, the 31st of January, rather late in the day, there was a notation on the case summary page maintained by the clerk of court for Ada County, dated January 29th, 2025. It's unclear why this notation was not published on the 29th or 30th, why it took until the 31st of January to do so. But nonetheless, if you go to the case summary page, January 29th, you will see notice of filing. This is a public document. We know that because it has a PDF next to it. It is a list of stipulated exhibits for motions to suppress and motion for Frank's hearing. Now, what does this mean? Well, stipulation, a stipulated motion, is an agreement of some kind. The parties have come together and they have agreed. In this case, they're agreeing to exhibits that perhaps one side or the other side filed previously prior to these hearings on January 23rd and 24th. And now they're saying to the court, these are the exhibits that we stipulate to, that we agree should be designated as exhibits for these hearings. 1, motions to suppress. 2, motion for a Frank's hearing. And usually, when you see a stipulation like this, it might be for trial purposes. If the parties can stipulate in advance to exhibits that may be used for trial or for a hearing, they'll get together and say, yes, exhibit 1's fine, exhibit 2's fine, exhibit 3 fine, exhibit 4, 5, and 6, nah, we're not going to stipulate to that. We're not going to agree to that. Well, we're going to go ahead and submit to the court what we do agree to in terms of exhibits. What the court will be doing here undoubtedly is then citing to these exhibits that have been stipulated to in any rulings. That's my best guess that I give as an opinion pursuant to the First Amendment. So, unsure what's going to be granted in the multiple motions to suppress. They were all filed November 14th. You can take a look on the docket and read what is public. Several things are under seal. And certainly the motion for a Frank's hearing was also filed on the 14th with a memorandum and supporting details filed on the 18th. And then came the court's order of the 22nd saying that the organization of the memorandum with something like 2,000 exhibits was not specified. There were duplicate items, and that led to the defense having to file the amended memorandum with exhibits as they did on November 26th. So we're going to wait and see what this stipulation says. As soon as it's published on the docket, we will report back to you. Until then, this is Kathy. Thank you for joining us here today.